Good morning. In the previous two videos, we have seen the distinction between crime, tort and contract, and today also we are going to continue the distinction between the three concepts. Okay. Now what is crime? Crime is a public wrong. As it is a public wrong, that is a crime is an offense, you can say it is an act against the whole society. Therefore, who files a case? The state files a case. It is a public wrong. Okay. Now, tort and contract, breach of contract. What they are? They are breach of a private right. So it is a private wrong. So, private person has to file a case. So, what we have seen here, it is in crime, it is a violation of a public right. That is, it is a public wrong. And in tort and contract, it is a violation of a private right. It is a private wrong. Therefore, the aggrieved person, that is the victim himself, files a case. Okay. Now this is one of the difference between crime, tort and contract. Okay. Now we will see about vicarious liability. What is vicarious liability? It is a substitute. Means when a person is liable not for his own wrong, he has not done any wrong, he is liable for the wrongs done by some other person. He is called as a vicar, a substitute. This is called as vicarious liability. Like if a servant does any wrong, then the master becomes liable. If the agent does any wrong, then the principal is liable. Though there are certain exceptions and all. But this is a general rule that principal is liable for the wrongs of agent. Master is liable for the wrongs of servant. The company is liable for the wrongs of its directors. Okay. The firm is liable for the wrongs done by the partners, guardians, that is the parents and all. They are also sometimes liable for the wrongs done by their children or ward. And the owner is liable sometimes for the wrongs done by the servants of the independent contractor. These are the 6 relationships which you have seen in tort, that they are liable. It means what? I am telling tort. It means the concept of vicarious liability is there in tort. Okay, where the person is liable for the wrongs done not by him but by some other person. Because here we apply the principle qui facit per alium facit per se. He who does the act through another does it himself. And we also apply here the concept of respondent superior. Okay. So the concept of vicarious liability is there in tort. But there is no concept of vicarious liability in crime. The criminal himself will be liable. Okay. Now when an act is there which is crime also and a tort also, then in crime the concerned offender will be liable. But if it is a tort, then for tort some other person can be made liable. Take an example, rash and negligent driving causing death. The driver will be liable. But the owner of the vehicle, the insurance company will be liable in tort for giving compensation. Okay. So vicarious liability concept is there in tort. It is not there in crime. It is also not there in contract. There is no concept of vicarious liability in contract. Okay. Now we will see the position of a drunkard. A drunkard person is for a few period when he has taken that intoxicating thing, for that few period his mental condition is not proper. Okay. Now such a drunkard, what is his position in contract, in tort and in crime? Okay, in contract what we see, when a drunkard person has entered into a contract when he was affected by the drunkenness, that contract is void. Okay, because he is not proper person, he is not a competent person. Indian Contract Act clearly states that a person who is minor cannot enter into contract. A person who is sound mind can enter into contract. Means a person who is major, sound mind and not disqualified by law, they can enter into contract. So sound mind person is required, not unsound. And drunkenness for that particular period is unsound. So at that period if he enters into contract, the contract is void. Okay. Now we'll see the position in tort. drunkenness is no defense. If a drunkard person commits a tort, he is having a property, his property is liable. The victim, the aggrieved person, can take compensation from the drunkard's property. Okay, but where mental condition is very much essential in tort, there the drunkard is not liable. Okay, now we'll see in crime. Drunkard, but he is not a voluntary drunk, means here the drunkenness has been divided as voluntary and involuntary. If a person is involuntary drunk, that is against his will and without his consent, then only involuntary drunk is not liable. Nothing is an offense is done by a person when he has been intoxicated, and this intoxicating thing has been given to him against his will, against his consent, then only he will not be liable. Otherwise, a drunkard person, if he commits a crime, he is liable. Okay, so this is the position of a drunkard. Now we'll see the concept of unsound mind. In crime, how it is? Nothing is an offense. It is done by a person who, because of his mental condition, he is not able to understand what he is doing, whether he is doing contrary to law or not, where he does not know any consequences and all. Then means because of unsoundness of mind, if he commits any crime, then it is not a crime because he is unsound. While doing it, that is essential, while doing it, he does not know anything. He is affected by some mental condition, mental depravity is there. He is unsound, then it is not a crime. Okay, in tort, what we have seen, if an unsound person does any tort, it is not a good defense, means an unsound person is liable. Unsound person is liable in tort because he is having the property. From that property, the victim can take compensation. But where the tort requires mental condition as an essential factor, there the unsound person is not liable because he is lacking that mental condition. He does not know anything because of that unsoundness of mind. Okay. Now in contract. In contract, what is the position of unsound? We have seen for entering into a contract, two parties are required and these two parties should be competent to contract. Competency to contract means he should be major and sound mind. Okay, sound mind means what? He knows everything. He understands everything. He is called as sound. He understands the same thing in the same sense. He knows every repercussions. He knows on what he is giving the signature, for what he is giving the consent. He is called as sound. So an unsound mind person is not a proper person to enter into a contract. Now this unsound mind person can be either an idiot, he can be either a lunatic, or he can be either a drunkard. So drunkard person, if he enters into a contract, when he is under drunkenness, the effect of drink, the effect of intoxication is there, then his contract is void. Okay, an idiot is a person who does not understand anything, small things also, and there is no chance that he can recover from that disease, you can say. He is not able to understand anything now and hereafter also. He is completely unsound only. So when an idiot enters into a contract, that is also void because he does not know anything. But a lunatic person is a person who is sometimes sound and sometimes unsound. Means when he is sound, he knows everything. He is like a sane person only. But when he is unsound, he does not know anything. So lunatic is a person who is sometimes sound and sometimes unsound. So when he enters into a contract when he was unsound, that contract is void. But when he enters into a contract when he was sound, then it is a valid contract. Means here the obligation will be there to prove when the unsound person has entered into a contract. That is when the lunatic has entered into a contract, whether he was sound or not. Okay, this is the position of unsound mind in crime, tort and contract. Here we have completed the distinction between the three concepts. Okay, in three videos we have seen this distinction. See completely all the three videos and then you will understand how the three concepts differ from each other. Okay, bye bye. See you in the next video. with a new concept.